Hello. Hi, András. Can you hear me? I cannot hear you.
I'm not sure. Hi.
Hey.
Hi.
So nice to see you.
Nice to see you too.
Hi, Jimena. Very nice to see you.
Can you hear me?
Now, yes.
Okay, great. Hi to both of you.
And I can see that Jeff is here too.
Yes, I am here.
Hi.
Can you hear me okay?
Yes, very well.
All right. How's it going?
Fine, very well. And you?
Good, thank you.
Already the Christmas mug?
Yeah, it's actually, it's my dad's, it's apparently some golfing mug. I'm visiting my parents down in Florida with my kids. My wife and her mom are taking advantage of a deep discount and going to the Galapagos Islands to scuba dive right now. So I am solo parenting here down in Florida. So if you hear kids in the background while I'm talking, they're homeschooling right now, and there's nothing else I can do about it. So
no, please don't worry. I am also in a kid's room.
Okay.
I just try to kind of hide it.
I've given up any pretense of being proper right now. Hold on one sec.
Sure. While we are preparing, I would like to introduce to you Gustavo Villacreces, who is one of the co-editors of the newly founded USFQ Law working papers. And he has been a great help for me, and he's going to be here with us to help with all the technical issues. He's going to handle the Facebook and everything. So we are on air, online, live. Thank you very much, Gustavo.
Good morning. Thank you, Joanna, and really nice to meet you all. And I want to thank you for your time, for your knowledge you're going to share this morning or this afternoon for you, I guess. And thank you so much for accepting this invitation from Joanna and from us, from USFQ Law Working Papers Editorial Committee. It's a pleasure for us. And most of all, I think it's a great opportunity you are giving to our audience, to our young audience, and we are really pleased to hear you, learn from you, and having you here, not in Ecuador, but close to Ecuador. Thank you so much.
My pleasure. My wife and her mom will be spending about 12 hours in Guayaquil today. They will.
Yes.
They will.
So you're a little bit closer.
I'm a little bit closer. Yeah, I'm down in Florida right now, so which is better than Indiana right now.
Yes. How is it, like hard-wired winter already?
You know, it is 33 degrees and sunny right now in Indiana. Fahrenheit. So it's 1 degree centigrade.
Well,
we have a cold front here in Florida, though. It's like in the 50s or 60s, which is cold for them, but I'm in shorts. So
great. And András, you are in Salzburg or in?
No, actually, we live in Vienna, and it's even prohibited to travel now to Salzburg, the university, because it's closed down. So all teaching is online. So sitting in the flat, actually, I'm sitting in the living room. Family is just out for a walk, so maybe I have to run quickly with my computer back to the bedroom table. But yeah, it's Vienna, actually. Vienna.
Nice. One second. Yeah.
Great. So we have 2 more minutes. We are going to wait for that because before to start, and even before is like
help
unthinkable. We are going to wait. I see there are some people in the waiting room, so I guess they are going to connect from 9:30 sharp or some minutes later, perhaps. So, but in any case, we are going to start in time. And so they, as I told you, to all of you, first I'm going to give some introductory words, And I'm going to talk very shortly, very briefly about this initiative of the USFQ law working papers, and obviously clarify a little bit the context of this webinar, which is the first webinar of a series that we are preparing in order to give the opportunity for this new generation of lawyers, and for obviously all the lawyers and academics in Ecuador and around. There will be various participants also from Chile, from other countries, from Colombia as far as we know. And then we are going to, I'm going to give you the word, introduce you obviously, and give you the word in the order that appears in the poster. So first I'm going to give the word to András, then Jimena, and finally to Jeffrey. And then, well, it depends a little bit on the dynamic that is to evolve among us. If you prefer, we can also do for a few minutes a discussion among us, among you, which I will only moderate. And then I am going to receive questions in the chat, and I'm going to moderate those questions. And if we have time, I will put forward some of them to you, and we will see how this goes. So there is a certain structure which is flexible depending on the dynamic of the discussion among us and the questions. I don't know if you have any doubts or any questions before we start.
I think it's a great plan. The only thing is I just want to apologize because in exactly 90 minutes or 85 minutes I have to leave because I have another meeting. But so 1.5 hours is
Yes.
the time slot I have. But yeah, thanks.
Yes. Thank you very much, of course.
Joanna, I don't know if we are ready. In that case, I can let the people in.
Yeah.
Okay.
Yes.
Now we're ready, John.
Okay. Okay, thank you very much. I would like to give an especially warm welcome to all the participants and especially to the speakers of this first event, of the first webinar that we are organizing in the framework of the USFQ law working papers. This first webinar is about the topic of successful academic writing for young legal scholars. There are a lot of concepts and a lot of things to actually clarify already in the title, but this is one of the challenges of today's workshop, today's webinar. So here we have with us 3 distinguished scholars and academics, and more than anything, 3 good friends and colleagues, András Jakab from the University of Salzburg, Jimena Soleil from the Berlin-Postdam research group, and Jeffrey Pojanovsky from the Law School of University of Notre Dame. Before I give the word to them, I would like to very briefly introduce this new initiative that now ex-students of the USFQ Law School are continuing, and that we have started like a year ago in the framework of the Law School of the USFQ University. This initiative is about creating a new opportunity for those lawyers, those scholars who have the wish and desire to publish with an academic rigor, but at the same time they would like to reach out to the public discourse, reach out to citizens. And in order to do that, we created a new platform of legal publication, which is called USFQ Law Working Papers. The co-editors of these USFQ Law Working Papers are here with us today. They are going to post our webpage in the chat. You can check that out. You can visit this webpage for more information about how to publish, what are the requirements. But our goal is really to kind of transform and better the quality of public and legal discourse in Latin America, in Ecuador, through building and creating new channels of dialogue. So actually, this webinar is going to go beyond merely showing you like a productivity guide or something like that to how to publish more. Of course, we can clarify what successful academic writing means, but for sure, this webinar is going to be also about a mission or a vision of academic dialogue in which all of us are trying to participate and in which all of us are trying to contribute. So, and some technical information. So you can write in the chat questions, which I am going to put forward and moderate after the presentations of our speakers. And of course, depending on how much time we have, I'm going to put forward as much as I can. And I think now I am going to give the word to our first speaker, Professor András Jakab from the University of Salzburg, a professor of Austrian constitutional and administrative law, who is also co-editor of the Austrian Journal of Public Law, and previously, among many other positions that he have been holding, he's been a full professor at the Catholic University of Pázmány-Péter in Budapest, and also the director of the Institute for Legal Studies of the Hungarian Academy of Sciences. So I am very, very pleased to give the word to you, András, and the floor is yours.
Thank you very much, Johanna. Thank you for the invitation. Basically, I will just take a couple of minutes to talk about my own experience and my own failures in the past when I wrote my first papers, and I hope that they are going to be useful for those who are listening to us. And I will mention a few generic piece of advice that might be useful to those who are at the beginning of their career and thinking about how to write academic papers in the field of law. So I think there are different role models for legal scholarship, and what you consider as a usual role for a legal scholar or a good paper in one country, it's not necessarily a good paper or a good role model in another country. So what I'm going to talk about is mainly how I think that the standards of, or what I think the standards of good academic writing in continental Europe. So just a caveat at the beginning of what I'm going to talk about. I mean, first of all, in the choice of topic is an issue that we all face. So what kind of topic we want to write about it, and I basically have two advice about that. First of all, you need to love the topic, you need to find it interesting, and second, it needs to be puzzling and difficult. If you have both, then you have a good chance that you will have enough enthusiasm that gives you enough energy to write a good paper. Second is try to, with most topics, you cannot read all the literature. So you have to be selective, and it's a difficult issue how you select the papers or the books that are relevant for your topic. And my advice would be that try to find the key texts of the debates, and you can find the key text by glancing through a larger number of literature and having a look what they refer to. And once you identify the key text, then you should be very thorough with the key texts that you're working through. Also, recent literature overviews can be pretty useful for this purpose. So if others have already done the job of drawing up a map of the debates, then you should use it. Once you read the substantial amount of literature, my advice is to write as soon as you can, and then once you have a text or a sketch or a skeleton text, then you can always improve it. But I don't think that that's a good method to try to read basically everything and then write something. I think the whole once you have enough material that you work through, then you should try to have a skeleton of your paper and then try to improve it step by step. And finally, what's the most important thing is try to get as much feedback as possible. Try to get feedback from your peers who are same age or in the same position. Show papers to each other, talk about them, and also show it to some senior academics if you can in your environment, and try to use their feedback to improve your paper. I think legal scholarship is not like mathematics where you can just sit in a room and possibly 20 years later you come out with a great idea. In legal academia, good works or good ideas develop through feedback and through dialogue with each other. So try to use that with your colleagues on the spot or now electronically. So it's much easier to get feedback from colleagues wherever in the world. In general, I would say that it is always better to write less papers. Often I see that young academics try to publish many papers and they are like so half ready. So it's better to concentrate on a few good papers than try to publish many half-ready ones. So try to be actually perfectionist, but not perfectionist to the degree that it would freeze you. And Joanna sent me a few questions. I'm not sure what the procedure would be. I can talk about those questions, or I also don't want to monopolize the micro, so maybe others can talk. I don't know. Shall I go through the questions that you sent me, Joanna, or what?
Well, of course, there is no obligation, but if those questions fit in your general framework of the presentation.
Okay, I mean, I go through a few of them, and if I have some ideas, I can say my ideas, and possibly we're also going to disagree on the panel. That would actually make it more interesting. So, how would you say that writing commentaries is different from a research project? That's an interesting question. I mean, in legal academia, we often write commentaries of civil code or case notes, and then how does it relate to research projects? I think what we have as a genre commentary in legal literature, that is always doctrinal. So that's the genre is doctrinal. So it's about conceptual systematization and developing new concepts, explaining the relationship between concepts. It's a doctrinal genre, or how you say in German, rechtsdogmatics, doctrinal genre. And it doesn't necessarily need to be innovative. So what is expected is more being systematic and being disciplined. Whereas in a research project, you do need to be disciplined and systematic, but you definitely need to be innovative. So if a research project is not innovative, then it's not a good research project. But a commentary, if it's not innovative, it can still be a good commentary. So I think the standards are different. And also in a research project, the genre is not necessarily doctrinal. It can be also sociological, theoretical, or or some interdisciplinary project, partly with political philosophy or science, and though. In a commentary, it's not the case. In a commentary, that's a classical genre of continental legal scholarship. You need to develop concepts, the relationship of concepts, the system of concepts. So I think it's different. The standards are different in traditional commentaries and research projects. That's one of the reasons actually why legal scholars have difficulties to acquire major research grants. Actually, the kind of the traditional key genre of legal scholarship, at least in continental legal systems, is doctrinal analysis. But in a doctrinal analysis, you are not innovative. If you are not innovative, you don't have a hypothesis and so on. And for all major research grants and research agencies, normally you need a hypothesis and you need this structure of empirical research, and you don't have that in legal scholarship.
Sorry, András, for interrupting. I don't know if you hear me. Maybe your speaker has some problems, or there are these continuous noise, something like physical noise around the. I don't know if it's just because it was very hard to understand what you were saying.
Okay. So
like
I'm sorry about that. I don't know actually what was it. So just quickly, I think legal scholarship, at least the standards of legal scholarship are different from empirical standards or the standards of empirical scholarship. In traditional continental legal scholarship, we expect systematization, conceptual sophistication, but we don't expect any innovation, or not much. Whereas for research projects or research grants, you expect innovation, and you expect a hypothesis that has to be proven or falsified. That's not the case in legal scholarship. So I think the standards are different. Other question that you sent me as preparation: in longer research topics such as the use of force, how does one make the cut as to when to begin the narrative in order to detail the tradition, but not to summarize the whole tradition? I mean, my generic advice would be just to, at the beginning, just to give a short, just to mention a few words about the issue, and then in literature references you can refer the reader to more detailed historical information. How to do a literature review well or successfully? I think literature reviews are very important. They are good in order to make a map. So a good literature review is not just about a ton of information. It's about grouping and comparing like opinions, comparing opinions and showing trends. If you can do that, then your literature review will be received well in the community, I think. In order to better define the scope of a paper, is it a good idea to start by identifying the law journal in which the article would be published? It's often said actually that you should tailor your publication towards the law journal that you want to publish in. As a matter of fact, at least in my career, I've never done so. So what I've always done is I fell in love with the topic, and then I wrote about it, and then sooner or later I found a good forum or a good journal that published it. But I know people who do the other way around. So it's just a kind of personal experience, and for me it works. For other people, probably something else works. What would you recommend for those who are writing their first article in a foreign language? Well, get a native speaker to check it. It is very unfair, but the truth is that no matter how smart you are, you write a paper, in a foreign language in poor quality, then you won't get published. So it is unfair, but you have to adjust and you have to get a native speaker to check it. There is, I mean, the international academic environment is merciless in that sense, at least publishing in good law journals, that's not going to work without getting a native speaker who can check it. And should we occupy a firm posture in our articles, how to deal with our own doubts, uncertainties, fears, to make errors? And my advice would be to make a clear point always. And if you do not have a clear point yet, then think more and read more. And it's too early to publish then. And finally, my final remark would be, it's about the question, what guarantees more readers for an article in your opinion, content, arguments, etc., or the level of publicity? I think what I've learned in the last, actually now decades, it sounds scary. So in the last decades, since I've been working in legal academia, is that basically every article and more or less books also survive in the form of a key sentence or a key thesis. So if you want your academic work to be quoted, then first of all, you should have a clear point. And second, you should communicate this clear point in the title or in the subtitle. Because there are so many articles that if you hide your fantastic idea somewhere on page 5 in the second paragraph from the bottom, no one ever will notice it. So you need to be as clear and as loud with it as you can. And the best way is you have to do that is have your clear point, what you want to say, and put it normally in the title or in the subtitle. So maybe these are the first remarks, and obviously I'm curious what my colleagues are going to say about these issues.
Right. Very well. Thank you very much, András. Thank you very much. It was great. And you know, the first point that you mentioned, that definitely there is a different role model or an ideal type of lawyer, even in different countries or different legal cultures. That's absolutely relevant for our question today. And actually, this is like one reason why we considered to invite all of you, is that you represent a type of successful legal scholar in continental Europe, in the US, and Jimena is, however, working in Europe. And obviously, maybe you are considered as a very successful legal scholar in both the continental Europe and in Latin America, but definitely here in Latin America, it is, I would say, these role models are under a transformation, and new legal scholars, or the new generations of lawyers are under a transformation. And that would be very, very interesting to mark these differences in focus or differences in these role models, or what is that perhaps is different, or how to be able to publish well with a high quality in an academic environment where this transformation is on the way. Sorry. So. And of course, there are thousands of other questions, but I will not steal more time. And I will give the word to Jimena Soleil, who is right now a postdoctoral research fellow in the Berlin-Postdam research group of international rule of law, rise or decline. And she was previously also a research fellow at the Max Planck Institute for comparative law and international public law. And also published various things in various different legal cultures, I would say. So I am very, very pleased to give you the word, Jimena.
Thank you. Can you all hear me? Yes? Okay. So thank you for this invitation, for all of you who are listening, for spending some valuable hours of your Wednesday morning learning about academic writing, and also for giving me the opportunity to reflect on what my own research and writing process has been like. So I would like to make sort of my own disclaimers now that András started with the disclaimers. I have been working for the past 10 years in Germany as a full-time academic. So this means that I know very good practitioners / academics, and I've thought about how I would like to do scholarly discourse if I have to leave academia, but I don't actually have the practical experience. So my experience is, my advice can only be limited by that. So I'll do 3 things. I'll sort of break down my presentation into 3 topics. The first one is choosing a topic, which is something that András already talked about. The second one is I'm going to take some of your own questions and do a type of Q&A on how to be a good pracademic. And then the third one is on the importance of critique and discussion. So how to choose a topic. And so basically I've had, there was one particular question that says, how do you define a research program beyond something that is fashionable or in the news? And I have 2 experiences with this, because I wrote a paper on a topic that was incredibly fashionable, and I knew it was fashionable at the time, and that's backlash. And then I wrote about the court as transformative in a moment when that wasn't fashionable at all. It was just a question that was really sort of burning within me. So why did I choose to run on the bandwagon of a fashionable topic? I didn't do it because I wanted sort of a lot of citations or because I wanted a lot of downloads, but I did it because I thought I had something to contribute to the conversation, because I had been dealing with aspects of this topic for many years before. And not only that, I joined forces with someone who had been dealing with different dimensions of the problem also for many years before. And this was my colleague Sylvia Steiniger, who's a political scientist. So in a way, what we did was we jumped on the bandwagon because we also wanted to change the framework of the conversation. We were noticing that every single scholar, whenever there was some disagreement or there was a lack of compliance with the decision, they were calling it backlash and kind of contributing to this sense of crisis of the system, of the inter-American system. And since I had kind of like the long-term historical view of the history of the system and the very different instances of backlash and resistance, I could bring that together with the political science framework and say something about it. So, so what's the first tidbit of wisdom is, write about what you know. If you're going to write about a fashionable topic, make sure you know already something about it. Now, the more essential question: what happens, especially at the beginning of the career? What happens if you don't really know much about anything because you're at the beginning of your career, and you need to pick an area of the law to develop expertise in? And this is where I agree sort of wholeheartedly with what András said, is find a question that you are burning with curiosity to answer. Sort of something that will keep you interested for months or years, something you can't answer right now and that you need to sort of acquire a lot of knowledge and information in order to be able to answer it. And then sort of maybe another aspect that for me was important in choosing sort of to research on the Inter-American Court of Human Rights, on human rights, is that I made my topic sort of, I wove it with my identity in a certain way. So I've spent a decade in Germany, but I spent most of my working hours thinking about Latin American phenomena, reading sort of literature that is also produced by other Latin Americans from Latin America, going to conferences and meeting sort of all these wonderful Latin Americans. I work in rights because, I care about struggles to emancipate the individual. I write about courts because I think that institutions are essentially sort of a positive thing in society. So basically, maybe I'm just being sort of overly romantic, but what keeps you motivated is to make a topic that is truly your own, that is very difficult. If you're going to spend so many years thinking about it, choose wisely. All right, so now I'd like to sort of field a bit some of your questions on how to be a good practitioner / academic. So many of you, so I told you about how I decided to write about my PhD topic and about my backlash paper. And these were kind of problems that more of like a full-time researcher would face. But how would you address the situation if you have a 9-to-5 job in the field of the law? Here I would say is write about something you know. So what I've seen sort of from the very best academics is that they write about the area of the law they work in. Because the day only has so many hours. If you spend 9 to 5 working in one area of the law, and you only have a couple of hours to dedicate to academic work, you should not be researching completely unrelated legal topics. If you do, know that it will take a long time for you to be able to make any meaningful contribution to the topic. So, and here I'd like to highlight something. Practitioners have a very valuable contribution to make to legal discourse, because they know how certain areas of the law operate in real life. And this is something that academics don't always truly know. They pick up on problems that are not visible in academic discourse, and sometimes they know a lot more about the context that give rise to certain developments. So what I would say is, this is not a handicap, sort of embrace this unique perspective that you have to the law and bring it into your academic work. This brings me to one of the questions that one of you posed, which is it better to be present and write about many different topics or to specialize in a strictly concentrated topic or research area? And this reminds me of sort of some law professors I had in Costa Rica who basically thought they could write about anything. And so they were writing about criminal law and about civil law and about environmental law. And they're just saying a lot of very superficial things about the areas of the law, and they weren't experts in anything. So if the premise is to make a contribution to the discussion, be humble, accept your limitations. And you can only be an expert in specific areas. Don't add to the noise, only write about it if you have something valuable or interesting to say. Okay, so more questions. What guarantees more readers for an article in your opinion? The content or arguments, or the level of publicity and advertising? And here, I really don't want to minimize the importance of diffusion strategies, especially in social media, but content always gets priority over diffusion. If a piece is, unoriginal, if it's derivative, it just repeats what others says, it doesn't add anything new. If it's unclear, if it does not add anything to the debate, then, diffusion will get you initial downloads, and then you won't get any citations, and interest in your piece will die down very quickly. Another question, how do we go beyond purely reporting or describing legal issues, and basically sort of adding something new? And here, sort of András explained it very well, kind of the difference in genres, in how you write, because there are types of legal writing, case notes, commentaries, that are generally more descriptive, and they're also necessary to legal discourse, and they're also necessary for practitioners, and they're also valuable. But even within this specific genre, there's kind of like a good way and a bad way of I think there could be a good way and a bad way of doing something. So I like to give you the example of a case note that I got the other day that I needed to peer review whether it was going to be published in a journal or not. And I want to point out what the author did right and what I think the author did wrong. So what did they do right? They offered like a very good summary of the judgment. They recognized sort of the most relevant legal issues, those that are under discussion or novel, and they tied the specific judgment to sort of broader legal questions without making a claim of their own, because that's not the point in a case comment. What was the bad? So even though the author correctly identifies problematic aspects of the judgment or the decision, they start just rendering an opinion without taking into consideration what has been written about the topic before. So you don't even have citations to like one or two of the leading piece on the matter. They did not engage with what was already there. So basically it was a monologue and not a conversation. And it's also frankly a bit arrogant to think you don't need to know the state of the discussion before jumping in and giving your own opinion on the matter. Okay, so that we're talking about opinion, I'll go to the question on opinions. Should we occupy a firm posture in our articles? And how do we deal with our own doubts, uncertainties, and fears to make errors? And sort of, I guess, my answer is a bit more nuanced than András's, because I don't think there's one clear answer to this. Sort of, it truly depends on the type of piece you are writing, how much knowledge you have on it, and how certain you are of your position. I generally think it's okay not to make a strong claim in every piece you write. And it's okay sometimes to be more descriptive. It's okay sometimes to come to the conclusion that you find an issue ambiguous, or that you see merit in many different positions. And in general terms, I would say every time you make a stance, and these are the most interesting articles, actually, the ones where you make a stance, you should make the premises of your argument explicit. You should open up your argument in order for it to be attacked eventually and for you to have to defend it. You should construct your arguments like an edifice that needs to be able to stand on their own. And you also need to acknowledge sometimes and address the weaknesses in your own arguments, because you want to be a perfectionist, but not too much of a perfectionist. So sometimes you have something valuable to add to discussion, but you haven't figured it out completely yet. And it's okay to say, like, I figured out this much, and this is still unclear, or this still needs more research. Okay. Johanna, could you tell me how I am with the time? Because I don't want to overdo it.
Yes, of course. I think now we are like 15 minutes to both of you. So if you want, you can have absolutely like 5 more minutes.
Perfect. Okay. I think that will be enough. So one of the questions was how to articulate personal opinion in an academic article, especially if it's a controversial topic. And this is obviously a really tricky question. Your work is obviously a reflection of who you are, and some of like your deep-seated convictions and ideas about the law are necessarily going to be present in your academic work. But I guess knowing a bit the Latin American tradition of sometimes writing opinion pieces disguised as law, what I would say is, first of all, be very true to your craft and your discipline, the discipline that you are making this critique in. Sort of, okay, what does this mean? If you are going to criticize or support illegal interpretation, do it for principled reasons, and not only because you disagree or agree with a certain outcome. Translate your beliefs into the logic of legal discourse in order for them to be of any relevance for academia. So if you're going to do it carefully, respectfully, in accordance with the rules of our craft, and then trying to add something to the discussion. So now I'd like to close off with, I think, sort of the most important part of academic work, and that's discussion and critique. And many of the questions you asked, which I didn't address directly, there was someone, how to structure an academic piece? Is my literature review good enough? Is my claim well-founded? Are my arguments strong? All of these questions will only become evident if you manage to, if you manage to do it or not. It will only become evident if you subject your work to discussion and critique. And I spent many years at the Max Planck Institute, and we have many different discussion rounds, but there's one in particular that was brutal and kind of like the best school possible on how to do good research. And this was a meeting we had every Tuesday, and everyone had to at some point present pieces of their work. Some of them were very raw, unfinished, or rough drafts. Everyone had to do it, sort of the big professors, the lowly PhD students, the guests, everyone. And everyone was eviscerated in a collegial, mostly, manner. And basically, it's a humbling experience. It's a great exercise, and it's the best thing you can do to improve the quality of your academic writing. Because what I saw in my experience is even the best academics write really terrible first drafts often. And you need this input from your peers in order to improve it. And of course, you can wait a long time and then try to present a near perfect draft, but it will go a lot quicker and it'll be less painless if you just subject yourself to like 2 hours of hearing everything that is wrong with your research. You'll definitely learn from it. And of course, it's scary. And if some of you are starting out and you think like, oh no, I can't do that, that's too scary. Then start out small, so give it to a friend. And then give it to someone who's not a friend, but who you respect, and then present it to a bigger audience. But yeah, so now just a couple of closing words, and then I hope we get some other questions and some debate. Is if I have to summarize everything, it's write about what you know, find something you are truly fascinated about. Don't put it out into the world if you're not making any contribution to legal debate. Substantiate any claims you make to the best of your reasoning abilities, and subject your work to criticism and look at it as a necessary step to produce good scholarship. Thanks.
Thank you very much, Hima. This was really, really, really fascinating to listen to. If I imagine a video of like an executive summary of this webinar, I could cut like a lot of cool parts from what you have just said. And I'm sure we are going to get back to various points that you and András has already touched upon, maybe in the presentation of Jeffrey or in the discussion part. So thank you very much. And now I would like to give the word to Professor Jeffrey Podjanowski, a full professor of the Law School of the University of Notre Dame, also a co-editor of the American Journal of Jurisprudence, and a great academic, and a great academic who is actually communicating to very well the results and arguments and points of discussion continuously of his work, and a great friend and colleague in this academic community. So I am very pleased to give you the word, Jeffrey.
Thank you very much, and thank you for having me here today. I apologize in advance in case in the event children appear either visually or audibly, I have a virtual homeschool children in an open planned house, so we may have some visitors. So when I thought about this, I think I might be able to be uniquely or particularly helpful for the audience we have here, because when I started my academic career, I made the transition from practitioner to scholar. And you know, the American path, I say about half of the people have PhDs and go straight to the academy. I'd say about half practice and then join the academy. So I worked for judges for 2 years, then I practiced law for 2 years, and then I made the transition to scholarship. And my sense from the questions that we've received is that there's a decent number of people in that position now. And the question is, how do I go from being an intellectually or interested or scholarly inclined lawyer to being a scholar of the law? And that's tricky because although the two, we hope, connect, the crafts are different. And so what I'll talk about is paper topic selection and developing a research agenda as you're transitioning from being a practitioner to a scholar. So I think about and figuring out paper topics to write is the hardest thing. Trying to figure out what is a good topic is often just as challenging as about how to develop the topic you've chosen. And so let's say you are either, you know, towards the end of your scholarly time, or you're practicing and you want to make the transition. How do you know what to write about? And I certainly agree with the advice, write about what you know. Don't decide to become an expert in some unrelated field. I mean, you can if you want, or if you happen to be kind of marooned in a practice you don't like and you want to write about something else, do it. But let's say you're practicing in a field of law and you find it interesting, and you find a particular case that you're working on interesting. Now, the first mistake that a scholar, a practitioner who wants to be a scholar will be like, well, I'm just going to write up a glorified legal brief about this question I'm interested in, right? And you know, good briefs will have scholarly components to them and try to systematize the law and make sense of it. But that's not the same thing as scholarship. So what you want to do is, okay, so you got this case or that you're interested in, that kind of like piques your intellectual interest. Your impulse should be not to kind of attempt to do a scholarly write-up about how to resolve this particular case or resolve this particular problem. The question you should ask is, what about this case or what about this area I'm working in strikes me as particularly interesting? Why do I find this to be a particularly interesting case? Why do I find this to be a particularly interesting kind of problem I'm doing if I'm doing a transaction or something like that, right? So focus on that and write about that. But don't just write about that. The next question you ask is, why do I find that question interesting? What are the broader issues or questions that particular problem tees up? And that's what you should be writing about. The particular questions or particular problems that make that particular legal question interesting. So for example, when I was working, I was working on a case that implicated a question of judicial deference to possibly judicial deference to an administrative interpretation. And it was a really interesting question because the statute seemed to implicate a kind of common law, a background common law concept. And the question is, well, like, should agencies get deference on not just, you know, general questions of statutory interpretation, but which is a well-written theme in the United States, but statutory provisions that implicate questions of the common law. And so that's the question I thought was interesting about that case. And then why do I think that question is interesting? Well, it tees up really interesting questions about the philosophy of common law and the distinction between common law and statute, and how the structure of that problem informs broader questions about whether, you know, why and when we defer to judicial interpretations of statutes, right? So I find a case that was I could have very easily kind of written up a paper. I'm like, the court should not defer on this question, on this case. Or I could just write another paper on, you know, different agency interpretations of law. But I found kind of an interesting niche interesting, corner of the law that hadn't been written about. But I didn't just write about that corner of the law. I tried to write about the broader issues that corner of the law implicates. And that's where you can really make your contribution. And that's where you can connect, and it's going back to the previous speaker's discussion, you can leverage your experience as a practitioner, your contextual knowledge of the law, your ability to see problems that other scholars don't see, but then you can draw on your broader reading and your broader theoretical reflections to shed new light on an issue. So that's, and so if you're looking for your first paper or two, that's one possible way to go about it. And then the question is, how do you develop a research agenda? Now, I went on the market with one paper and a made-up research agenda because I had to have a research agenda, right? So like, I made up a whole bunch of possible papers that I thought I might write someday, and like try to tie together some theme. And like, frankly, no one called me on my BS. I've written none of those papers. There is some relationship to my research agenda, but I don't recommend doing that. I got very lucky. I'll link this together with developing topics on papers. So I agree that you should not try to write a whole bunch really early. You should try to have your papers should be few and good. But that doesn't mean you should. But you also need to. There's kind of a chicken and the egg problem. Like, to present yourself as an academic, you can't just be there with one paper. You need to have like here's what I'm going to be writing about, right? And so this will tie into kind of writing your first paper and then thinking about future papers. The first paper topic you hit on may not be a good one, right? And you don't want to spend a year writing a really big paper, showing it to people and discover it's deeply flawed, right? So how do you avoid doing that? One thing to do, and this is just good general paper writing in general, write up do your reading, do your thinking, try to write up a basically 2 or 3 page summary of the argument of what you're going to do. Like, name the problem, name your solution, and pitch it, right? It's easy to kind of have your friends read it. If there's a senior scholar who you trust, it's actually an easier ask than saying, can you read my 40-page paper? You can say, hey, does this sound like it works, right? And you you may find in the process of trying to write that 3-page summary that it doesn't work. And then you stop and move on, right? Or you'll see, I need to change it, and then you modify it. Or you may share it and they say, you know what, no, I think you need to kind of shift it 15, 20 degrees. And then you've got a good paper. And the amount of investment you need to do in that is less than what you're going to need to do in writing a 40 or 50-page paper. And the lead up work you'll still have to be there, but you won't spend 40 to 50 pages of writing. And I agree that early feedback is really important. So one of my, a paper that turned out to be really successful, I pitched it to a colleague of mine in kind of embryonic form, and she says, you know what, like, what you're dealing with is kind of too small bore of an issue. It implicates this broader question, and that's what you should be writing about. So for example, I was thinking about writing, like, again, this kind of statutory interpretation in common law. I was thinking about this doctrine of negligence per se, where if you violate a statute as a matter of law, it's deemed to be a breach in the common law of tort. And I was writing about, well, that doesn't, that kind of approach to statutory interpretation in the common law seems weird to how we do it in public law, and that's kind of a problem. And my senior colleague's like, well, don't just write about negligence per se, right? There's a bigger issue about, like, look, federal courts think about statutory interpretation one way because of constitutional structure, and federal courts don't think of themselves as common law courts, but state courts are different. And no one really writes about how debates in statutory interpretation in federal courts should bear on interpretation of statutes in common law courts, which arguably have different powers, right? And so 3 papers later, kind of flesh out that larger problem. And if I hadn't gone to my senior colleague, who, by the way, that senior colleague is now Justice Amy Coney Barrett, if I had not gone to that senior colleague early on, I would have written a fine paper on negligence per se, but I wouldn't have been hitting on this bigger issue. And so going early on to present papers, ideas in embryonic form can be really helpful, because it's that shift it by 20% or widen the frame by 30%, and you've got a really good paper. It's much better to discover that early on than later. Now, how does this relate to a research agenda? So you don't want to write a whole bunch of papers early on. You're not going to have the time. If you're practicing, you're not going to have the bandwidth. But you might want to have 2 or 3, work on one good paper. You might want to have 2 or 3 ideas in the bag, though, right? And if you have those 2 or 3 ideas in the bag that you haven't fully developed into a paper, you may identify there's kind of a common theme of questions that you're investigating. Is there a commonality? Is there a thread? Is there a type of question or a type of problem that seems to be recurring in the cases or papers you find kind of interesting? And there you can connect the dots, and there you have a research agenda, right? You see, it's not just this paper I'm interested in, and this paper, and this paper, and this paper. What is it about that links these kinds of things together that point towards a broader problem or a broader set of questions or kind of methodological approach that you want to attack? And lo and behold, there you have a research agenda. You have because what people want to see on the teaching market is not just a good paper. They certainly want to see a good paper, but they want to see where you're going. They want to see what paper 2, 3, and 4 are going to be, not just because they want to read paper 2, 3, and 4, but they want to know what you're about. And the direction of where your scholarship's going to go. And you can only discover that by having 2 or 3 or 4 ideas that you want to work with, or at least understanding what holds those things together. And once you understand what holds those things together, you kind of have the kinds of problems you want to approach, and you can identify the kind of scholar you want to be. And again, having a research agenda, it's not just going to be subject area and topic. It's the way you approach these subject areas and the way you approach these topics that forms a coherent research agenda. And so I think that's how you go from writing commentaries or being a case lawyer to doing scholarly research, how you develop a research agenda. And again, I'm going to agree with my colleagues here. Whether it's fashionable or not, go with what you think, what you're passionate and what you're interested in. Now, if it's something deeply obscure that no one's going to care about, well, good luck. But you don't need to chase the most fashionable thing. And the law is large. There's lots and lots of areas to be written about. And sometimes going in and taking on the most fashionable issues or the hottest issues, the chances are the low-hanging fruit is going to be taken. The obvious positions are going to be taken out. I mean, maybe if you're going to try to want to maximize your exposure or find areas that haven't been written about, go slightly off angle. Find if there's something that's kind of interesting and exciting. What are the questions that are surrounding it, or what are the background theoretical questions that issue is gesturing at, and write about that. But most importantly, try to find something that you're really passionate about and really interested about, and identify what kinds of questions interest you. So I think I don't have much to add besides that, in part because I think my previous colleagues gave really good advice. So I think maybe I'll stop here and move to the Q&A.
Very well, thank you very much, Jeffrey. I think I will start. We have received some questions, and I think, looking at the questions we received, we will have time for me to occupy the first question a little bit to guide the discussion towards being on the other side, let's say, because all of you very interestingly talked until now about you as researchers, scholars who are writing, academic writers. And so what do you see on the other side, like editors of journals, editors of different legal publications? What are the most common mistakes or errors, or simply, simply things that early career young lawyers appear to commit in the beginning when they are trying to, following even your guidance, they are trying to publish their first, second, third article, and what would you tell to them from that perspective? And if you want, we can follow the same order. Yes, so I will give you the word, András.
Thank you. So basically, I'm also editing a journal currently, the Austrian Journal of Public Law, and we also have a double-blind peer review system, but we as the editors apply a first filter. So there are certain papers that we don't even send to double-blind, and the most common mistakes where papers fail is bad linguistic quality. That I mean, we publish both in German and in English, and obviously it applies to those who have another native tongue. So bad linguistic quality, if it's unclear what they want to say, so you need to have a clear point. So linguistic quality, clear point, and at least the most obvious literature should be quoted, or somehow they should show that they know kind of the basic literature in the topic. If these three are not given, then that's an immediate rejection. And if these three are given, and then it more or less makes sense, then we're gonna send it to an expert for double-blind review.
I forgot to say something which could be directed especially to you, who founded various of these law working papers. So from that perspective, to if you could add that actually. Okay. Our editors are trying to do here, who are present.
Yeah. So yeah, that's a different thing. So I mean, that's about law journals. This is how you can fail. The law. I mean, the working papers can be useful. I mean, on the one hand, you try to get feedback about your manuscripts, but then you have more or less, enough feedback. You already have like a pretty decent piece, but then until you get it published in a really good law journal, that can take a long time, 1 year or sometimes even longer. And in the meantime, you want to spread your ideas, and an excellent opportunity for that is to publish it either as a working paper that you can put up on any website, or in some repository, or some working papers are in repositories like this SSR and Social Science Network. That's also pretty useful. So that's basically a way to pre-publish your work. Some publishers actually don't like it, but most of them kind of do swallow it, even though they don't like it, because normally they don't pay anyway, anything for our papers that they publish. So that's basically a way to spread your ideas well before it is actually published, which is pretty slow. And it can also be useful in order to get some more feedback, even though I don't think that's the primary function of working papers, because then in manuscript form you should get normally the feedback, but that can be a secondary point. And for working papers, obviously you don't have these blind review processes. That's why it's also faster. So it can just be, it's also not printed, it's just in a PDF, and download it on the internet. So it's faster, it's easier, but obviously it's also less prestigious. So if you want a paper, you don't want the paper to end up as a working paper, because that somehow implies that you didn't make it. So you didn't get it published in a good law journal. So yeah, maybe that's.
Thank you very much, Jimena.
I'll be very brief, because I've actually never been in the position of editor yet. No, so I've only been in the position of peer reviewer, and here I'm almost sort of repeating myself. Sometimes I've gotten some pieces for peer review where I really wonder whether I'm the first external person to be reading the piece, or just like one of the first. So so yeah, don't submit something to a journal if you haven't submitted it even to your friends and to the peers you're actually closest to. And I'll reserve the time in case one of the questions relates a bit more to me.
No worries, of course. Jeffrey?
Yeah, I mean, I think András has excellent advice here. I think language is important. And even if you're a native speaker, clear writing is really important too, if you're submitting to an English language journal. Because if it's a slog to read, I mean, even if you have great ideas, people bother to try to read Habermas, notwithstanding his language. Yeah, but not everyone's Habermas, right? So try to be clear. Try to be clear and concise. And if you're submitting to something that's not your first language, then have a native English speaker work with it. And secondly, be clear about what your contribution is. Don't overclaim. Especially for junior scholars, especially in the United States, there's this pressure to say, this is a paradigm shifting paper. There's this question people have been overlooking for ages, and luckily I am here to clear all the confusion in the world. Don't do that, right? Like say, most papers are like, I am making an incremental contribution on a long-standing problem is kind of what you should be doing. But be clear what that contribution is. And so why this? Why does this need to be published? Because I mean, I get some papers that are well written that are just kind of like summaries of what's going on, and they're kind of useful, I guess, but we're not going to publish that. So kind of tell the reader why this paper exists, and what the contribution is. I mean, you're gonna have to do some literature review. You're gonna have to kind of let people know the state of play, but have something new to say. It doesn't have to be path breaking and groundbreaking. Not every paper is the problem of social cost or something like that. But be clear about what that is. And on working papers, I agree. I think it's good to get your stuff. It's neat to be able to get your stuff out, especially if you have a really long peer review process. One caution, and again, this is trade-offs. If it's out there are some unscrupulous peer reviewers who will kind of Google to try to figure out who the author is, right? And to take out one blind off the end of the double blinding. And if you're worried that a peer reviewer is going to like poo-poo something because it's not by someone established or something like that, if you're Joe Nobody, which is which I am as a junior when I was a junior scholar or in practice. If someone Googles it and finds out it's just by some practitioner in Chile or something like that, there's a risk that they just may discount it unfairly. And so that may be something on the peer review process. If submitting to American journals where there's students selecting, which is its whole other ball of wax, generating some buzz can be helpful. And so maybe kind of posting on SSRN, especially if you get like Larry Solom to link to it on the legal theory blog or something like that, might be helpful. But I could see it being a double-edged sword with respect to working paper series for unestablished scholars working with peer reviewers who unfairly only want to print people who are well established or people they know.
Thank you very much. I'm thinking about now making two questions that are coming from the public to two little questions, and make another round, and then at the very end, because I can see we are going very dynamically, so maybe at the very end I can make a more like a less technical question, if there is time for that, of course, depending on you. So the two questions that are coming from the public is, one of them is, what kind of conclusion do you think one should arrive to in a scholarly article? Meaning, should it be very closed or open? I guess they mean open to further consideration, or open to be incorrect, or to be changed, how sharp it should be. And the other one is, do we have to have necessarily a research agenda, especially for someone who has not yet found their niche? And I guess this is related to what you, Jeffrey, mentioned.
Can I hop in on the research agenda point? I guess I'm thinking, I don't know how the academic market works outside of the United States, whether in South America or Europe. I do know on the teaching market in the United States, you need to have a paper, preferably more than one, but they're going to want to know what your research agenda is, before you're hired. I don't think you need to have some sort of formal research agenda document when you're just writing on your own as a practitioner. You don't need to submit that with your articles and stuff like that. And I think it's good to have an idea about the kind of stuff you're interested in and kind of planning papers and stuff like that. But when I was thinking about having a research agenda, I think I was mainly thinking in terms of kind of if you're going to go in the teaching market, or if you're looking for a job. And again, that may be irrelevant in non-US markets, but that's what I was mainly talking about. And since I'm here on conclusions, I think it's just going to matter on the nature of the paper, right? I think different people vary. I think some people will say, I won't read a paper unless it's got a really firm conclusion or something like that, or strongly advocates for a point. I think that's too strong. I mean, I don't think you want to have a paper that just says, well, on the one hand this, and on the one hand that. Interesting. You don't want to do that. But you could say, look, I've written papers. I think on balance, I think, this is probably the better way to resolve it. But, there are good kind of counter arguments, and, the fact that it's not, and these are the considerations we think about when we're kind of weighing which way we're going to go, right? I don't want to pretend to be more certain than I am. And I think there are some papers that are interesting because saying, look, not just on the one hand, on the other hand, this is hard. You say, well, look, even if we think this is hard and I'm not going to firmly come down one way or the other way, here's the problem that makes this hard. And here's the kind of central question we need to kind of work out and think through. And I think that could be a contribution. Saying, look, there's this kind of clash about how we should resolve this, but it's really pointing to this deeper, more important question, and that's what we need to think through to kind of resolve this. And you don't have to resolve that in that one paper. So I'm not the kind of person who says, like, you should finish a paper like it's a brief and say this is firmly the right way. I mean, look, if you've got firm views, stick the landing, defend it, be principled about it, and don't shy away, but don't sound more certain than you are. And if you think it's hard, explain why you think it's hard. And that's an interesting contribution as well.
Very, very well. Jimena or András?
Okay. So I'd like to pick up on this sort of strong conclusions thing. And I think I did a bit in my presentation. And here I would have to agree, you don't always have to have a super strong stance on things, particularly when you would essentially need to fake it, this strong stance, or you would have to ignore many of the problems that you see, because as scholars, kind of like, we don't always need someone to tell us what the problem is. We already know what it is. We're just trying to evade it a little bit. But then be honest to yourself and see, like, if your argument has a problem, then don't make it, or try to point out what the problem in your argument or in your conclusions sort of is. Well, don't make conclusions that have a problem. But essentially, you can tone down your conclusions, and that will still make for a perfectly good paper, particularly if you point out the problems in coming to a too clear-cut conclusion on a particular topic. And I deal with human rights, so a lot of sort of the disagreements that we have on interpretations go really deeply into disagreements in society. So it's always good, particularly if you want to continue speaking to your colleagues who don't necessarily share all of your opinions, to acknowledge the difficulty of taking a clear stance on certain legal issues. And then on the need to have a research agenda if you have not found your niche, Right. So this research agenda, kind of like this plan to take over the world and sort of in my next 10 years and articles I'm going to write, etc. That's not something you need if you haven't found your niche. But you should be thinking about what is the area of the law that I'm interested in, that I want to acquire expertise in order to, at some point, be able to make a contribution to it. And that is something you should be thinking about instead of sort of taking a year to write a paper on this and a year to write a paper on that, and you're not really concentrating on anything, and so you're not really, probably not writing the best of papers. So that's it.
Thank you very much, András.
Yeah, thank you. So just 2 questions is how open the conclusion of a paper can be. I mean, I think I'm a bit stricter on that point than Jeffrey or Jimena. I think you need to have a really clear point. It's true that, in fact, sometimes the problems are complex and it's not clear. But if you, I mean, there is basically an infinite amount of academic papers that want to be read, or that we should all read. We cannot read all the academic papers in our research field nowadays. So you actually, if you read academic papers, you expect that they have a clear point. And if they don't have a clear point, then they're not going to be successful. Maybe they will get published. I think it's also difficult to get published if you don't have a very clear point. But even if they get published, they're not going to be quoted, because the way academic papers live or they exist is through quotes in other academic papers. And they're going to be quoted if they have a clear point. The clear point can actually even be false, and then they can be quoted as absolutely mistaken opinions. But you need to say, you need to stand for something, and you need to say it clearly. Sometimes I think you can even exaggerate a little bit if you think that a certain point of view is ignored in the literature. And I think the best types of academic papers are which have approximated the narrative that so far everybody said A, but I think they were all wrong, because in fact it's B. So something where you can explain that there is a commonplace in the literature and that's wrong. And it's difficult to find it. And obviously it's a commonplace because most people find it convincing. So it's a difficult thing to find some, but these are the best papers. And it doesn't need to be something really big. I don't know. You shouldn't write a new paper about the concept of law, but something like, you know, on a lower abstraction level, but something where you can attack commonplaces or generic views in the literature, and you can say they were all wrong, and this is what I'm saying. And maybe you're wrong again, but at least you should say something. That would be my advice. And about the research agenda, I think you shouldn't consider it as something formal. I mean, obviously for an application, you have to write a research agenda. But I do think that in your head, obviously, you should have kind of an idea what kind of topics typically you are interested in and what you want to write about it. I mean, in that sense, I think it's natural to have a research agenda. And obviously, the research agenda is always much longer than it's physically possible. So, I mean, I have a research agenda probably for 200 years, which I'm not going to manage in my life. But I think it's normal for everybody. And then one way or another, you pick a few of them that you can implement. So that's it. Thanks.
Thank you very much. And I think maybe a very last round of questions that we can maybe start with you, András, and then obviously when you will have to go, it's more than understandable. So on the one hand, it has been very interesting to see this contrast between what we consider as a successful academic writing, so like getting published or getting cited or getting more citations. But what I wanted to pick as a last question is, which many of you have touched upon already, is disagreement in academic writing, and through doing it well, contributing to a true, open, honest dialogue in academic writing. So do you think there is a language, a style, or let's be provocative, a content of academic disagreement, and how to disagree in a good academic quality in a cultured academic community?
Yeah, so I would begin because, as I mentioned earlier, I have to apologize, but in 10 minutes I have another meeting, so just quickly my opinion about that. I think that also about academic disagreement, there are cultural issues. In certain cultures or legal cultures or academic cultures, it's very tough or very harsh. I mean, in German conferences, the people tell each other that they are wrong. And my impression is that in the UK, they actually never tell each other they are wrong, but they formulate it as questions. They say, I'm wondering how you could accommodate this idea to your theory, which in Germany would mean that was absolutely wrong what you said. So it's also a linguistic cultural issue, how they relate to each other. I think you need to have disagreement, and also in order to have your clear point, you need to disagree with everybody else. But my advice would be, because when I was young and I was wide, I was extremely harsh with other academics, writing footnotes wrong or mistaken. And I think you shouldn't do that. It's very, when you're young and you're wide, you kind of, this, you want to show that you know it better. And even if you do it, don't show it. So choose your words very politely and carefully. It should be clear. So instead of wrong or mistaken, you should probably write on a different opinion with which I disagree for this and that reason. But I think it's important that you show the differences, that you disagree with in a nice way. Thank you again.
Thank you very much, András, for everything. Yes, I don't know, Jimena, if you want to continue or.
Sure. Disagreement. So as I said, I'm Latin American, and I go to many conferences where it's also full of Latin American scholars, and I see a huge difference between the type of culture of legal discussion and disagreement between very old scholars and kind of younger ones, particularly those who have spent some time in the US or in Europe and who just are embedded in kind of a different legal culture. So disagreement is so important in scholarly discourse, because if we all just continue agreeing, then there's really essentially no need to write many new things. However, I guess there are some tips in order to disagree. The first one is, don't build a straw man if you want to disagree with someone. So really take their claims seriously. Read what they're saying, try to understand their arguments, and then you can pick them apart. But only after you've kind of done the work to engage with it seriously, and you're not simplifying it to the point where you're battling a straw man. Also, disagreeing is incredibly fun, especially if you're disagreeing with one of the great persons, because it means you really have to bring your best game to the table. You cannot be a lazy disagreeer, especially if you're disagreeing with the authorities on your topic. So even try to do it as an exercise, and if at the end you can't really publish it because it's not that strong, it's okay. But it's really, you're gonna do it, sort of bring your A game. And then really watch out for issues of culture and diplomacy and how you express disagreement, because you are disagreeing with a person's arguments about the law. You are not rejecting the person because of a particular position that they have. So if you want to continue to be a valued member of the scholarly legal community, then you also have to behave yourself in how you disagree with people. But don't run away from disagreement just because it's a big name. Please don't.
Yeah, I agree with everything she said. I mean, it's tempting to try to want to make a name for yourself by going after someone big and trying to take him or her down, right? Or get attention by being super combative. And you may get attention, but it may not be the kind you want ultimately. I think, I mean, most of what we're writing about, when we disagree with people, the reason why people are writing about it and disagreeing about it most of the time for most purposes is because these questions are really hard, right? And you have really smart people who are also working hard on these questions. And if you disagree with them, and it's interesting and it's good to disagree, you should do it in a way that recognizes the fact that, look, these are the people I'm disagreeing with are smart people who are working really hard on this too, right? And I'm coming down differently, and here's why. But I just kind of think of the I've ever seen the movie The Princess Bride, or the character's like, have you ever heard of Aristotle, Plato? And the guy's like, yes. He's like, morons, all of them, right? Like, you don't want to be that guy, right? Because I mean, it could be that you're the world historical figure. You could just waltz in and upset the entire field as you come in. Chances are that's probably not the case. There's only so many world historical figures to go around and paradigm shifters to go around. That doesn't mean you don't have anything new to say. That doesn't mean you have, status quos to kind of upset or complicate, and that's good. But do it in a way that recognizes the kind of the nature and the character of the debate and the complexity of the questions. And if you do make a good point, your credibility goes up even more. And so I think that's important. And I do think culture is important too. And it can vary by field. In public law, or I guess in administrative law in the United States, or statutory interpretation, people disagree, but they're pretty collegial about it, which is kind of surprising given the stakes in public law, at least for now. And top level, statutory interpretation and admin law scholars, they disagree with each other, but they get on pretty well. Jurisprudence in the United States is an entirely different manner. I remember going to a first jurisprudence conference I went to, and opening question, the guy raises his hand and says, your paper is premised on a cascading series of interpretive errors about HLA Hart, and went on for 4 minutes about how this junior scholar didn't understand analytic jurisprudence. And that's awful. I think it's gotten better. So maybe some areas may allow more combat than others, but even when places are combative, I don't recommend kind of playing along. I think dialing down the temperature is a good thing. Again, don't be milquetoast and bland, and be interesting and have interesting arguments and take on status quo if you think the status quo is wrong, but be graceful about it. And again, to not slightly disagree, but maybe disagree and emphasis with what András says, in the American Legal Academy, it's almost become hackneyed to say, like, to have the counterintuitive thesis. The status quo says X. People for 50 years have thought it always been X. Luckily, world, I am here as a junior scholar to tell you it's not X, right? And on big questions, the chances are that it's like that you're going to have this kind of Copernican revolution with your paper. Maybe, but have some nuance there, and you want to complicate the status quo or shed new light on it or challenge assumptions, but not everyone's Copernicus, and I guess it goes back to my don't overclaim.
Thank you very much. Well, this has been incredibly interesting, really. I just can hope that we will be able to somehow, sometime, somewhere, continue and come back to these issues. And we are extremely in time. So in the next 1 minute, I just really want to say thanks, especially to our speakers, Jimena and Jeffrey and András. It has been really a great honor to have you. And it has been very interesting and I think even provocative with the moderation, with the moderateness of what you have just said. It has been a provocation in many ways. And I think one thing that you all have been in accord with is that the best scholarly articles are coming from this burning curiosity to cite Jimena and others, and this true interest stemming from a desire to know more and to understand better things, and also academic humbleness, which I would point out as another thing. So, hello. And thank you very much. Thank you all of our public to come, all the editors of the USFQ law working papers, and have a very nice afternoon, a very nice evening, a very nice rest of the day. I send you all a big hug. Please have a nice day. Goodbye.
Thank you so much.
Thank you, Jimena. Ciao.